Hello everyone, this is David Fisher, Director and Founder of Immigration Chambers Limited, specialist immigration firm here in Auckland, New Zealand. I'm here today with our special guest, Ashleigh Fechney, who is an employment advocate, employment law specialist based in Wellington, New Zealand. And we've decided to have this online video to talk about employment issues and their interrelation with immigration issues here in New Zealand, specifically during this time of Covid-19, our lockdown. We're going to cover some issues like the wage subsidy. We've got a few questions from some of our clients about their specific situation that we're going to cover, and we're going to have a general chat. So welcome, Ashleigh. How are you today?
Good, thank you. Thank you for inviting me here.
Oh, thanks for coming. No, it's really good. I noticed that you've been doing some interviews on Radio New Zealand, some question and answer sessions. It seems that you have a similar philosophy as we do, and that is that really the focus is to help people, right?
Yeah.
To be ethical, to provide the right advice, and to essentially make sure that people can navigate their way through things effectively.
Yeah, absolutely. I think I first came under a lot of popularity after I noticed that no one was really talking about the wage subsidy scheme in normal people terms. You can read the declaration, but it's not easy for most. And only a few days into lockdown, I published this article about the wage subsidy scheme, and I got about 15,000 hits within a few days. And really, since then, my thought has just been, just get information out there, because people deserve to know in easy terms what their rights are during this time.
Yeah. No, that's right. And I guess, like I said, that's something that we have in common. And another thing that we have in common, I found out, is that we both come from a law background. You studied in Christchurch. You have a Master of Law, is that right?
Yep, yeah, I've got my Masters of Law, and I did pass with honours down in Canterbury. I've worked as a lawyer, I passed the bar, but now I've just chosen to work as an advocate, because I feel like an advocate forum is, I'm able to best help my clients, reduce costs. It's easier to just help the system.
Okay, so look, for the benefit of our audience, maybe you can just let us know specifically in your industry, what is the difference between a lawyer and an advocate? What is really the difference?
If you're talking basically, there isn't much of a difference in terms of the work that I can do. A lawyer, they've gone through law school, they've passed the bar, and they work at a law firm. An advocate, you don't need to have a law degree. I do, but you don't need one to act. And essentially, the only difference is that they can go to the Court of Appeal. So I can do everything up until that point, represent personal grievances, go to mediation, Employment Relations Authority, Employment Court, almost the entire way. And that's the only difference. There'd be a very, very small amount of cases that it would actually need a lawyer
Right.
to progress a case.
It sounds very similar to our immigration industry. We have a separate licensing. There's an act, there's the Immigration Advisors Licensing Act, which authorizes the licensing of immigration advisors after the completion of a certain course. I'm wondering, in the employment industry, is there a separate body that regulates people who do what you do?
At the moment, there's actually not a regulatory body. I'm personally I'm about to pay my bill to be a member of the Employment Law Institute of New Zealand. That does try to provide some sort of regulatory body with a complaints process, but there isn't a mandatory scheme, which I think that's one thing that employment law really does need. When it happens, who knows?
I have a feeling that what you're experiencing now is what immigration advisors experienced prior to the Immigration Advisors Licensing Act, where you're probably also noticing that if there's not a barrier to entry in the industry, you're going to find cowboys showing up, claiming to be specialists. And I've seen that myself.
Absolutely. And I guess that's one thing I'm trying to do as myself, is show people that not all advocates are like that. There are definitely some advocates, but you just need to do your research. Look at different companies, see what their reviews are like, and talk to them and see what sort of feel you get. Yeah.
Some people have criticized, in my industry, they've criticized the licensing regime simply for the fact that if somebody gets a license, then the public sees them as being therefore qualified to deal with their immigration matters. And that can cause, in my opinion and some other people's opinions, it can cause this kind of a false image of a standard. Whereas really what that does is it creates a minimum standard. Someone gets a license because they've passed a course, they've taken an examination, whereas actually having experience and going through things I always tell people you need to do your own research. You really need to look behind the person you're dealing with to find out, are they actually a specialist?
Yeah, absolutely. And I think also a lot of the term in immigration would be the same. Employment is a people-focused law,
Yeah.
and sometimes it's not just about what you read on the internet. It's about gelling with the person and really getting that connection, because we're going to be going through some tough times, and you want someone that you really trust.
That's right. Well, actually, that's a good point. This is something that I often notice with my clients. You know, there are really three things that people, in my experience, consider when they try to choose an advocate, a lawyer, an advisor, and that is, you know, the price. Is the price reasonable? Can I afford it? They consider, is the person competent, which means, you know, are they licensed or are they qualified? You know, can they do it? What I need them to do, which really should be a baseline anyway. Everybody who's in the industry should be able to do it in theory. But really what I've discovered, the reason that people really, you know, use or choose somebody for is service, and whether they like the person, whether they can get along with them, whether they answer the phone, whether you can actually work together, as you say, gel together. That's a good point. Okay, so you know, we had a brief chat about this before we started recording, but perhaps you can let me know your personal thoughts about how you see this playing out. You know, being that you're involved in the employment game, you know, what do you see happening out of COVID-19? What do you think is the end game here? What can we look forward to in the next 12 months, 24 months?
I know what we can hope to look forward to. I think that it's going to be a really challenging time for all businesses right now, and for the next few months. There will be, unfortunately, a lot of redundancies. A lot of people will become unemployed. I do hope that we do have a quick turnaround, which would mean more positions and jobs opening up. There are other industries that are thriving. I've noticed the job market, of course, the essential workers have been looking to take on extra employees. So there are some avenues, but in terms of employment, I think it's going to be somewhat grim for a little while. And one thing that I have noticed is a lot of employers are acting badly. They are taking knee-jerk reactions. They're also really stressed, but instead of stepping back and doing the process they're supposed to, they're just firing and making employees redundant without any process, without any consultation.
Yeah.
And I think, unfortunately, that's something we will keep seeing for a wee while.
Yeah, and the interesting thing about that is, again, there's a similarity with your industry and mine, in that I feel you can really boil down immigration law and practice to one sentence, and you can possibly do the same thing with employment law. Correct me if I'm wrong. Now, immigration, the Immigration Act, immigration regulations, when you really look into the legal framework, the legislative framework that creates the immigration law practice, it can be boiled down to the fact that the grant of a visa is an act of discretion, right? It is a sovereign nation's right to decide at its sole discretion who can come and who can stay, right? And so with employment law, I feel that you could probably boil it all down to that one you know, sentence, that employers and employees and parties to any agreement have to act in good faith.
Yep, and fairly and reasonably. That's pretty much the main words that are used all the time. Act in good faith and make decisions that are fair and reasonable in all the circumstances.
Yeah, because I mean, it's a contract, but it's a special type of contract, isn't it?
Yeah, I mean, because it's a contract that is really based around a relationship.
Yeah.
There has to be those feelings of just understanding each party, of being open and honest, having those good faith discussions. It's so important.
That's right. And there's a certain degree of an imbalance of the power, you know, ratio, isn't there?
Yeah, and that's why a lot of those terms are in there, because the law does recognise that inherently employees are more vulnerable. They're in a more vulnerable position. So a lot of the laws are around having employers making those conversations and trying to be open and making fair decisions.
Yeah. Yeah, okay. I mean, look, this is something that we see all the time in our field, that employers don't act in good faith. They make unilateral decisions. And quite often, look, I've even heard immigration lawyers and advisors try to defend this position too, that quite often the employer will say it's cultural. And I had a conversation recently with, now this is a specialist immigration lawyer. He's a friend of mine. And he made this comment that, hey, look, you know, David, it's cultural. And I said, well, that might be something that you can say because you come from that culture of the client, the specific person that we were speaking of. They were both from that same ethnic culture. And I said, well, that's fine, but I see culture differently. Culture is your music, your language, the food you eat, how you gather at certain occasions. We have laws here that protect employment relationships, and culture doesn't really come into the mix at that level, does it?
Absolutely. In the same way, essentially, the law is the law. The law is not what morals are. The law is not what culture is. The law is the law, and we have a really well-established system. And in terms of, I know the words fair and reasonable sound really vague, but we've got years upon years of case law and ideas about what that means, and that doesn't impact on maybe what's cultural in New Zealand and what we consider to be fair and reasonable as developed over hundreds of years, but it's a pretty fair baseline.
Sure. Okay. Well, why don't we start talking about these questions that we've got from our clients here about wage subsidy and other issues that have come up. I've got some specific questions that I wanted to cover with you today, get your thoughts on them. But first of all, the main things that are coming up about the wage subsidy are, we've got questions like this one. My employer has received the subsidy, but hasn't paid it to me. What can I do?
That one, I guess, practically, it's quite difficult. I do recommend, first of all, getting in touch with your employer. If your employer has received the subsidy for you, they must pay it to you, or they must return it to the government, depending on which is the most appropriate. If you can talk to them and you're discussing with them and they keep denying the right, you've got options then to, say, engage with a legal advisor or an advocate. We can look to try and progress the matter by writing letters. I know for me personally, I have actually raised personal grievances for this, and I have so far been successful. I can't guarantee it'll always be successful, but there are options available. Okay, and in the cases where you've been successful, what does success mean? Is that a like just getting the money? Or? Yeah, in practical terms, the people that I've been working with, they needed money right now, so they got back paid since the start of the period, and they'll be continued to pay for the next 12 weeks. I consider that as being a win, because otherwise they're going to keep going further and further into debt. They could have pursued the grievance to try and receive more remedies, but for them, just their livelihood right now was the most important thing. Sure, yeah, that makes sense. I mean, it seems quite straightforward to me that if an employer has claimed it, then at the very least they should be passing it on. The mind boggles as to how these employers, think they can get away with it. Yeah, absolutely. And there is an online complaints form, but similar to how the NBIE work with their labour inspectors, they're only really able to investigate the most serious claims. So if it's only one person that's not being paid, they might not be able to do much, but it can be helpful still to bring that to their attention, because you don't know how many other people are in the same boat. Yeah. Let's say, for example, somebody is in that situation where they know for a fact that the employer has claimed it on their behalf and it's not being passed on. And let's say they wanted to approach somebody like yourself to help them. What sort of cost or obligation would they be looking at? I mean, would it be prohibitive for them to employ somebody like yourself? No, so the first step, what I do is I always offer free initial advice anyway. I do try to empower employees to resolve their own situations. So the first advice I'd be giving is to go back to your employer and to have those discussions. If that doesn't work, they can come back to me. I do work on what's called a no-win, no-fee basis. So that means that I don't require any upfront costs, and instead, if there's a settlement, I take a portion of that. I am open to negotiate those when the settlement is, say, only receiving your income. And I have negotiated down, because I'm not in this to make money. I just want to make some meaningful change and to really help people. That's a great attitude. I mean, we all have to pay the bills, of course, but yeah, I guess you've figured out the secret. Okay, so the next question about the wage subsidy is, the government said my employer should pay me at least 80% for the subsidy, but I only received the base subsidy. How much, or should I really get paid for from this? We've seen this quite a lot as well, and we've been fielding the same queries.
I'll just let you know what I've been telling people, and maybe you can make your own comments as well. But I've been telling people, look, in the first instance, if you're working from home or not, but if you're working like normal, you're 40 hours a week, then your employer should be still paying you as per normal. That's the best scenario at the forefront. And if for some reason the employer is suffering a loss because of COVID-19, they're claiming the subsidy, and they want you to work full time, but they can't quite afford to, then at the very least they should be making their best endeavors to pay you 80%. And I would think that personally, the employer doesn't really have an argument to make if they're going to pay less than that, because anyway, you're working full time. At the very least, of course, they have to pay at least the minimum of the wage subsidy, the 585.20. There are some implications of that on their visas, but how do you see that? Am I correct?
Almost. So definitely, if you're working full time, you should be paid for your full time hours, and that's in accordance with your employment agreement. If you're working full time and your employer can't afford to pay you for those hours, the only way for them to pay you anything less is by agreement. Or they can look to do a restructure. I do often recommend employees to look to try and find other agreements. So it doesn't mean working 100% of hours and getting paid for 80%. You can agree to only work 80% of hours. If you're not working at all, the employer is meant to use their best endeavors to pay at least 80%. That's going to be quite a hard threshold to meet, and we don't quite know what that means right now. And if that's not possible, then they only pass on the subsidy. If you earn less than the subsidy usually, then you'll only be receiving what you usually earn, and the employer can use the rest of that subsidy to help top up other employees' wages.
Okay. Yeah, look, I mean, this is quite interesting for people who hold visas, because in many cases they'll have a visa which is dependent on them working a certain number of hours, usually minimum 30 hours for a work visa, and also dependent on them earning a certain amount per hour. So we get a lot of those calls saying, hey, look, my boss wants to pay me only 80%. What that means is that my income goes down below the threshold that I'm supposed to earn for my visa. And in those cases, we've been advising, okay, look, if in agreement you agree to go down to 80%, but you're also agreeing to reduce your hours by that amount, then your effective hourly rate is still the same. And if you're still working 30 hours per week and you're still effectively getting that hourly rate, your visa is safe. And if you're going below that amount for one reason or another, by mutual agreement with your employer, then we're advising people to keep good records, because they'll have to explain themselves in the future when they're applying for their next visa as to why they breached the conditions of their visa, because it is a technical breach. Now, I guess differently with employment law, with technical breaches of immigration practice, of immigration, like the visas, they don't necessarily result in penalties per se. It just means there can be difficulties in applying for the next visa. But in terms of breaches of the contract, what type of penalties would be available if the employee suddenly finds themselves getting paid less than they think they're entitled to?
So for breach of contract, the first look for remedy is essentially to rectify the situation. So if the employee is being paid less than what they would have been, then you can claim for those top up of wages. And that's just for a technical breach. Also, you can claim for legal costs. If it's serious enough that it amounts to a personal grievance, then you can claim for the loss, but also an amount for, I guess, your hurt and humiliation, like those personal feelings that you've suffered. But employment law does really have a lot to do with what's fair in the circumstances. So even if there is a technical breach, if it was fair in the circumstances because we are in this COVID-19 pandemic, then it will there'll be some sort of leniency.
I see. So you're thinking maybe if after all of this is over, we're going to see some cases in front of the Employment Relations Authority, also in front of the Employment Court, I'm sure. You have a feeling that perhaps the courts are going to be leaning towards, seeing maybe a relaxed approach than normal about what is fair and reasonable.
Yeah, there'll be a lot of case law that will be determined as a result of this. And so for a lot of my clients that I've been talking to, they say, well, I think I'm, entitled to 100% of my wages. I don't agree to anything less. Is this a breach? And I can say, well, I think so, but we're not really going to know until a few months down the track when someone's, I guess, brave enough to take their case to the Employment Relations Authority.
Interesting. Okay, well, let's see what comes out of that. Now, another question about the wage subsidy. My employer wants to make me redundant and doesn't want to keep me employed any longer. How much and how long am I eligible for the wage subsidy? And what happens if the employer stops paying me the wage subsidy?
So there's a lot of uncertainty, I guess, and depending on when they applied for the subsidy. So if an employer applied for the subsidy prior to the 27th of March, they can make redundancies, but they have to use their best endeavours not to. If they apply for it after the 27th, they're absolutely not allowed to. But the thing about redundancies, and this is what I've been advising my clients, is that if their position is up for redundancy, they need to put forward the solution that they will receive the subsidy while they're not working. When they are able to work, they will only work the amount of hours that means they will get paid the subsidy amount. And then after the 12-week period of the subsidy, they recognise that the employer might still conduct redundancies. Now, this solution, it's a fair solution and it costs nothing for the employer, but it gives the employee a little bit extra time, I guess, to come to grips with what's happening, but it also gives the employer a little bit more time to really understand what's happening with their business.
Yeah, I've been advising exactly the same thing. And it seems to me that there are some employers who themselves are confused about this. And they're, like you said earlier, they're jumping the gun, firing people, not realizing that it's safe to keep that person employed, pay them the wage subsidy while they're at home not working. And then, of course, during that 3-month period, watch the business, watch what happens, watch the economy, and just make sure they stay in touch with their staff about their plans and things moving forward.
Absolutely, and that is the right way around it, and I wish more employers would do it. That government subsidy is there to use, and they should use it.
Yeah, we have a specific question about something similar to that or related to this, which I sent you the more detailed email from these guys. So these are clients of mine who are, you could say stranded. This is the word that they use. They're stranded back in their home country, and they work for a big employer here. This is a big employer. And there is a huge imbalance of power with these guys. Just to give you the background in terms of immigration sense, these gentlemen, some of them, the ones that we're really wanting to talk about, are on what's called a work to residence visa. Now, work to residence is a special visa category that's available for people who are either falling under a special category of talent and meeting the requirements, or who have a job with an accredited employer. Accreditation under immigration means that they've gone through a process whereby the Ministry of Business, Innovation and Employment have assessed the business. It's financially stable, it has good human resource practices, good employment practices, good immigration practices, and they certify that the business can therefore offer jobs at a certain threshold of income, and the person who gets that visa will be eligible after 2 years in that employment to convert it to residence. So it's effectively a pathway to residence by way of that employment, different to other categories where you have to go through the points system, satisfy the normal requirements, education, qualifications, all of that kind of thing. So it's kind of like a golden ticket. If you are working for an accredited employer and you get that right salary, it's magic. And employers often, they know this, and they play that game of, I'm the sheriff, I hold the power, I've given you the visa. Now, I don't know that that's the case with the employer, that they're intentionally holding it over these workers, but the situation is they've gone home to their home country for a holiday, and in the meantime, the lockdown happened. The country they are in actually shut down before New Zealand did, so they haven't been able to come back. Now, initially, the employer had said straight away, like, your job is over from tomorrow, effective immediately. They had tried to invoke some immediate termination clause in the contract, and then they went back and they liaised with the employer and said, hey, look, what's going on? Can't we have some time? And they've been given a date in May, and they've been told effectively that if you can't make it back by that date, you're out. Now, the employer hasn't claimed the wage subsidy for these people. They've just gone straight away to redundancy. What's your feeling about this generally? Now, I know we can talk about this a little bit off camera, in more detail, but what's your feeling generally about people who find themselves in this situation?
There is a lot to consider, and I think the starting point is to remember that any decision that the employer makes must be fair and reasonable in the circumstances. So some of those circumstances to consider is, first of all, an employer can apply for the wage subsidy for a migrant worker who is trapped overseas, but only where that migrant worker had planned on a temporary stay. So if they already had annual leave booked in, if they've gone home because of COVID-19, then they won't be eligible for the wage subsidy.
Okay.
So that's one thing already to consider about whether it be fair and reasonable. The government's going to fund these people for a period of 12 weeks. So that may be a bit early. The second thing is to consider the nature of the business. Can the business, say, easily find replaceable staff? Do they have casual workers? They have temp workers? How easy is it for that just to prolong that decision? Because sometimes it's just a matter of timing. They say they will terminate in May, but what if the borders open up in June? So what they've really got to protect themselves with is that they've made that decision at the right point of time, considering everything else that's going on, and then at that point they might be able to consider it. Other factors, whether these workers can work from home in India or where they are. I know that this might bring about some jurisdictional issues, but that is another thing to consider. I think short answer is I don't have one. It will really be factor specific about whether an employer can terminate the employment, but the most important thing I think for the employee is to engage in conversations, discuss their ability to get home, what they're doing, the steps that they're taking, ask for a period of unpaid leave if they're not going to apply for the wage subsidy, because if you're on unpaid leave at that point and the employer can refill your role, they can easily get temp workers and casual workers in. It's going to be quite hard for them to look to dismiss straight away and ask for more time.
Tell me, in your experience, now obviously this is in relation to having a visa and the impact of the decisions on that visa, but let's imagine that there are other circumstances that are unique to a particular employee, whereby the decisions made by an employer and the way that they go about their negotiation with the employee have an extra disadvantage on the employee because of their unique circumstances. Do you find that the courts tend to bring that into the discussion of what's reasonable and fair under the circumstances?
Absolutely. So part of the what's fair in the circumstances also includes the circumstances of the employee themselves. So for example, let's just throw a left ball that if you've got an employee who is deaf and they go through a disciplinary process, of course there's going to be an expectation that there might be a sign language interpreter or someone to help them. So there are always different aspects you've got to consider for every single employee, and the employer still needs to make fair and reasonable decisions based on those facts.
Right. And so what I'm really getting at is, in this particular case, obviously the loss of the employment, outright redundancy, has such a serious effect on these people because they are migrants, because they hold a visa. And not only does it mean that they'll be without a job after this, and that they'll be in the same job market trying to find a new job as everyone else, but they may not even be able to come back to New Zealand, where they have a tenancy agreement, they're supposed to pay rent, they may even have other family members here, or other commitments, they've got a car, they've got, some of them have lived here for 7, 8, 9, 10 years. So in those particular unique circumstances, do you think the courts or the authorities would be looking at that and saying, hold on a second, this employer should have done more to try to retain the person?
Not necessarily. And that's only because when you're looking at redundancies, every person, it's supposed to be about their skills and their employment, not necessarily how it's going to impact them afterwards. But the impact after dismissal, it comes under that like hurt and humiliation head of remedy. So when you raise a personal grievance, there is a tax-free sum that you may be awarded, which helps to compensate you for how hard it has been to find a new job, the situation that you personally have been in. It doesn't necessarily stop how that decision making is made, but it does help with remedies after.
Look, obviously in terms of these particular cases, you wouldn't be able to comment, but generally speaking, under similar types of circumstances that are happening today, do you think personal grievances are a reasonable avenue for people to start looking at?
Oh, absolutely. And I think if someone has been dismissed or they've had some unfair treatment, they should consider it, but they do have 90 days from the date of that action. So you've also got a bit of time to really consider your options, consider if that's what you want to do. There's no, incredible rush, but it's absolute deadline of 90 days. And once you're outside of that, it's pretty hard to raise a grievance.
Sure. Yeah, okay. I think that's quite helpful for a lot of people because, as I mentioned earlier, a lot of migrants, they don't want to rock the boat. They feel afraid to take any action against their employer because it may affect their visa. And the reality is it does. The reality is, unfortunately, you can, even I had a conversation with somebody this morning who had assisted the ministry with an investigation against an employer, and the ministry then, or the immigration then uses the information he's provided to help them against him to decline a visa. So the reality is that migrants are disadvantaged on both sides. They get hurt by the employer, and then they get hurt if they do try to take their rights through the normal processes and avenues. But now that we're experiencing this situation, you're finding people are up against the wall. That they've reached their wits' end, and they're starting to look at these avenues. So it's quite helpful to talk about this. Personal grievances are going to be a thing that's a much more hot topic for migrants, I feel.
Oh, definitely. And for everyone, I can't tell you how many I've had to raise in just the past week alone. There's definitely been a lot happening.
Yeah. Okay. All right. Well, let's look at the next question that I have here. Okay. Oh, this should be a quick one. I have been made redundant with just a few days' notice. Is this notice period justifiable? Am I eligible for any redundancy, entitlements, or compensation? Oh no, I see we're having some audio problems. Let's just put the video on pause. Okay, so the next question about the, not the wage subsidy, or something else, but we should be able to get this through quickly. So I have been made redundant with just a few days' notice. Is this notice period justifiable? Am I eligible for any redundancy, entitlements, or compensation?
So the first thing is your notice. Your redundancy, if you're going to have a notice period, it's in your employment agreement. A lot of the times that might be 2 to 4 weeks, but check your employment agreement. That's what you're entitled to. And you should be either working that notice period or paid in lieu for it. The second thing is redundancy compensation. In New Zealand, there's actually no entitlement to redundancy compensation. There are some employment agreements, though, that do provide compensation. So again, check the employment agreement. That's what you're going to find out what you're entitled to.
Sure. Yeah, no, in most cases, people who hold a visa, in most cases, they'll find that there's no redundancy clause in the agreement. Many migrants are working themselves for migrants. And so you've got migrant employers hiring migrant employees. And it's quite common. I'm not sure if you've seen this a lot yourself, you probably have, but it's quite common in our field that we see employers and employees often have no idea what's in their agreement. They've signed the agreement because they used an advisor or a lawyer who said, you need one of these for your visa. And that was it. And very often they've been working for the employer prior to applying for the visa. Let's say when they had an open visa or something like that, they didn't need the contract. And they've signed the contract only for the purpose of getting the visa. Just on that point, employment agreements, what are the rules around that? Does everyone have to have one? What has to be in it, generally speaking?
Yes, everyone needs an employment agreement. And it's supposed to lay out, I guess, really the real basics of your employment. If we only talk about what has to be in it, you've got to have like a minimum guaranteed number of hours. It really should have your pay rate. It should have your role, where you're going to be working. But the reality is with employment agreements is that they can be formed and changed verbally. So one thing that I have to do in my role is to look at not only the employment agreement, but think, all right, you've been employed for 3 years. What has changed? A lot of people will have employment agreements that say you're working for a minimum of 12 hours, but at some point over their employment, there was a verbal agreement they would work full-time. And so at that point that verbal agreement's been made, that's going to be found to be what their term of employment is.
Okay, even if the agreement stipulates in writing that any changes must be made in writing?
Even if, yes, an agreement is an agreement, and the verbal agreement will always, I guess, will be the main one that the law looks at. I know that it can seem a bit, I guess, counter this idea about having a written agreement, but it's always going to look at what's actually happening in practice, because how an employee acts and how they conduct their employment is going to form, I guess, that proof of what their employment relationship looks like.
And I guess that's the principle that they teach in law school, which is you can't contract out of the law.
Yes.
Yeah. And I guess there's another point really to make for the benefit of people who haven't got legal training. You know, there's this idea that a contract is the piece of paper that's written down and signed. That itself is not a contract. That is simply evidence of a contract. Mm-hmm. And this is something that we also end up, you know, trying to explain to people that, yes, you've got something in writing, but this is something that reflects what you are supposed to have agreed. There are other things you can agree, which is off the paper. It's between the two of you, and that agreement forms the contract, not just the paper.
Absolutely. And I guess another common one that I'm finding recently is the employment agreement says that an employee is a casual. But what we find through practice is that this employee, say, has been working every Saturday for the last year. That employee is not a casual because they've been working routine hours and they're expected to work. And that's a good example of seeing how that works in practice. Even if there was never a verbal conversation that they would be a permanent employee, somehow that employment had morphed and changed over time. And that's at the end of it, that's what the law is going to look at, that they are a permanent employee.
Yeah, and I guess you see that a lot with employers who try to get their workers onto contract agreements rather than, you know, as a contractor rather than as a permanent employee. And they do this for their own ease of compliance, I suppose. And they think it somehow protects them because the worker has to pay their own tax and take care of their own expenses. Some of the workers get themselves into this thinking it's a bonus because they're not paying tax. It has its own implications, doesn't it? And then in the end, the courts will still look at it and say, well, the relationship is that of employment.
Exactly, or contractor. There's a lot of issues they need to discuss, but they're going to look at the real nature of the relationship, not what's written down on paper.
Fair enough, good point. Okay, let's have a look at the next question that we've got here. And this is reasonably common. My employer is taking advantage of me by forcing me to work longer hours than in my contract without extra pay. He threatens me that if I don't do it, he will cancel my visa. What can I do?
Well, I guess the first thing is if there is a clause in your contract, say if you're working salary, sometimes it will say you'll be remunerated, I don't know, $50,000 a year, and you agree that this is adequate compensation, that if you're required to work overtime, we don't have to pay you for it. So that is a common clause that's in there. Most people that are on hourly rate should be paid every hour they're done. And a lot of people on salary will also have an overtime clause. But the second thing that's actually really concerning is the threat. And I think that itself is quite an issue, and I would say that's disadvantageous in itself. And in fact, it possibly could even start to hinge on some human rights issues, because they are then threatening to really, I guess, affect that person's ability to live and work in New Zealand.
That's right. Yeah, we see this issue quite a lot. And I'm sad to say that the end result of more than 90% of these issues that come up is that nothing is done. You know, we will often encourage people to take this further, to make a complaint, file a grievance, to notify immigration. But as I said before, you know, the migrants are often afraid of how it will affect them in the future, and especially, you know, and rightly so, because often they are themselves complicit. That you know, it's a he said, she said, and they try to make a claim against the employer. The employer comes back and says, oh, well, actually, they are the ones who asked me to do like this to make the fake pay for their visa. And you never know what's actually going to come out in the mix that ends up damaging their future chances for visas.
Yeah, it's definitely something I've come up with, not even just now, but in the past, where, say, an employee is being bullied, and they're afraid to raise a personal grievance, to look to amend that or change it because their visa is so heavily reliant on their job.
Yeah.
And that could be really difficult. A personal grievance doesn't mean that you're going to have to end your job. And in fact, if you're still working, the whole idea about going through this process is to try and make your employment better.
Yeah.
But if I'm being frank, if all employers acted properly, I wouldn't have a job, and some do react. So I can understand that fear. It's not fair, it's not okay, but I understand that it happens.
Yeah. But ultimately, a claim can be made and employers can be made to pay if it's found that the person has been forced to work additional hours without pay. I was reading up on tax
Absolutely.
law, and look, I don't remember the name, but the one that I found was a case where it was a person whose visa did not allow them to work the additional hours, but ultimately in the end, they took this claim against the employer because they were forced to work the additional hours and the employer didn't pay for it. And the employer's defense was, your visa didn't allow you to work to work lawfully, so therefore I don't have to pay you. And the court basically said, well, no, there may be conflicting, or on the face of it, they may seem conflicting, but fundamentally, if you have worked and you have performed the work and you are due the pay, you should receive the pay. And they did enforce that, and the employer was made to pay a large sum to the employee for a period of time that they worked additional hours.
Yeah, absolutely. And I think one probably important thing to reach out from that is that immigration law doesn't necessarily change employment law, and employment law doesn't necessarily change immigration law. They're both there as avenues, and one doesn't necessarily impact the other. That employee might have had claims under both immigration and employment.
Yeah, that's right. Yeah, and it's the overlapping part is that, of course, you can say your visa doesn't allow you to work the extra hours, but you have worked them, and therefore you're supposed to get paid them under employment law.
Yes.
If you're not paid for those hours, all it is it's evidence that you've breached your visa conditions, but then at least it's compliance with the employment law, so it'll sort of cancels itself out. I've even seen cases like this where people have had successful claims against their employer for unpaid wages when the person was unlawful and not entitled to work at all. And the employment courts still said, no, you worked, so you get paid. Yeah. Absolutely,
that's how they look at illegal workers, so people that are paid under the table, and that's whether there's visa conditions or not. A worker who is being paid cash in hand and there's no taxes on it will still be found to be an employee. It's just there will be some serious repercussions for the employer at the end of the day in terms of when IRD then jump in and try and get the PAYE back off them.
Yeah. Oh, well, look, once we start bringing in tax law, it's a triumvirate of conflicting legal issues. We've seen them all. Just on a side note, someone was telling me about a case relating to employment and tax law where the employer had an employee who was stealing from them. And it turned out that they had stolen something like $100,000 over a period of time. And so it was an employment case that was taken about dismissal and this kind of thing. And that was the issue. But the end result was the IRD was chasing the employer for the tax on that money. Mm. And the employer says, hang on a second, I never got this money. It was revenue that was stolen from me. They say, exactly, it was revenue.
Yeah.
You earned the money, regardless of what happened to it. After you received it, you pay tax on it. So
yeah, and there can be a lot of different conflicting areas of law. I mean, on top of that as well, there quite possibly could have been a criminal conviction. It's quite funny sometimes how so many just come into play and to help, I guess, evolve a situation.
It's complicated, isn't it? Okay, let's have a look at another question here. The Labour Inspectorate has visited my workplace and told me that my employer is under investigation. They asked me if I want to make a complaint. What is going to happen to my employer, and will there be any trouble for me if I make a complaint?
Well, I think the first thing is that if you make a complaint, you shouldn't be worried about what happens to your employer. The reason the Labour Inspector is there is because there are already complaints. That employee should really be open and honest in assisting the Labour Inspector, and the employer can't discriminate or can't disadvantage. They can't do anything to that employee because they made that complaint. Not legally. Again, if employers were perfect, it wouldn't be here, but if something did happen, they would have a really good case. Yeah. In terms of what can happen, the Labour Inspector can then, raise a claim against the employer. And a lot of that time, it's usually penalty claims. So, for example, breach of the Minimum Wage Act or breach of the Holidays Act, they can bring quite a large scale. If this employee has been impacted financially, so they're not being paid minimum wage, they're not being paid their annual leave, the Labour Inspector can advance that on behalf of all the employees, and then can often make sure that all the employees involved in the claim are remedied for their loss.
That's right. That's my understanding as to why this person is being asked by the Labour Inspector if they want to make a complaint, because, they're fishing for evidence. and obviously B, if they do find that this employee hasn't been paid for every public holiday they worked or their annual leave, then they can enforce the employer to pay the money back. That's what they're looking for, isn't it?
Absolutely, and if there are already quite a few people that are taking action, the labour inspector is looking after, then it is easier to go with them, because otherwise, if the labour inspector pursues their claim and they get remedies for all these other people, but this employee didn't jump on the bandwagon, they'll then have to get their own legal advice and own representation and go through the process themselves.
You touched on something interesting, and that is, that you shouldn't really be considering or thinking about what's going to happen to the employer. You need to think about yourself. And this is something that we battle constantly because, as I said, migrants are in a position of vulnerability. They don't want to rock the boat. They're afraid that if they do something against the employer, they'll lose their job, lose their visa, lose their chance for residence, all of these things. But even besides that, what we find is that a lot of migrants develop an affinity with their employer, and they feel loyalty. And quite often it's because they've come from overseas. Maybe they've studied here, and then while they were students, they got a chance with this job. The employer gave them a chance. And if the employer did the very basic minimum under New Zealand employment law, then to some of these migrants, it seems like a magical, amazing opportunity. Minimum wage. Wow, this is $17, $18 an hour. That's more than I earn in a whole week back home. Or wow, this guy gives me a free lunch. My employer back home, beats me and tells me, do you know what I mean? There are horrible circumstances people are coming from. So they develop an affinity with the employer, and that they feel like, oh, I don't want to hurt them. They're going to be good for me. They promised me they'll support me on my next visa. They promised me they'll support me on residence. And I almost every time I end up telling these guys, say, look, don't trust your employer. Don't trust them. You may like them, don't trust them, because 9 times out of 10, when push comes to shove, they will make decisions based on their own economic circumstances. And I've seen it too many times. Sorry, mate, can't support you on your visa. I know you've only got 1 week left. Go and find another job. And they end up, falling out of the boat, even though they didn't try to rock it themselves.
Yeah, absolutely. As much as employers are making decisions for themselves in their own interests, employers should be doing the same, whether that's migrants or not. I know that, I guess sometimes it can be hard to know what your rights are and what you're entitled to, but that's why there are advocates like myself. There are other people giving free advice at this time as well. It's easier if you've got questions just to go out and reach out. You don't have to make a claim, but sometimes I think that there's a lot of empowerment just in knowing what your rights are, and maybe, emailing your employer yourself. It doesn't mean you have to go and make a claim. It doesn't mean you have to go and be confronted, but sometimes it's just enough to know what you're entitled to.
That's right. And this is something I'd say to everybody every time, migrants specifically. But if just think about that, New Zealand is a modern developed economy. It's a modern developed country. Plenty of migrants who are coming from UK, USA, Europe, other developed nations. They know this, but there are a large volume of migrants coming from, let's say, India, China, Africa, countries that really just don't have a comparable labour market. They don't have comparable laws, protections for vulnerable workers. Just wake up a little bit, and then just don't feel bad about standing up for your rights. Don't feel bad about it at all. At the end of the day, we all have to face our maker and put our hands on our heart and say that we did the right thing in life. And, sometimes it means standing up for something that you deserve.
Absolutely, and I think that's where a lot of my clients come from. They came from a basis of wanting to do the right thing, of being a principled approach. It's not about getting money. It's not about hurting the employer. It's about saying, look, what you did to me is wrong, and I need you to know that. And I think sometimes it doesn't have to be a bad thing. And a lot of people too, by raising claims or even just by making them aware, you can stop that from happening to someone else, or you can try and stop that from happening to someone else in the future.
Yeah, and I guess the other point you make, very valid, and that is to find a good advocate. Like we mentioned at the beginning of the conversation, what is an advocate? What is a lawyer? What's the difference? You have lawyers who study law deeply. Sometimes C's and D's still get degrees. This is what I've heard. And then you have advocates or advisors who maybe haven't necessarily studied law. They haven't necessarily gone deeply into those legal issues, but they're out to make a buck. They want to earn money. It's a business for them. And so, we want to find people who have a balanced background, balanced understanding, and as well, a good attitude. Someone who genuinely cares about you, genuinely wants to help you and support you in your goals.
Absolutely. And I think another thing to add as well is that an advocate doesn't need to have a law degree to be a good advocate. And I've met many advocates who have just had years of experience of, say, working in HR or working in the employment field. So I think also I don't want to go out and say you need to find someone with a law degree, but just go out and have a look and see who you like. A lot of us have reviews online, or you've got articles you can read, and even sometimes just we have a lot of these face-to-face conversations that you can really get to understand who you're talking to. And I think it's important too to really know straight up what costs are. And I guess, as you know, with a lot of law firms, they often require upfront payments, their retainers. Partners of law firms are charging, between $350 and $500 an hour.
Rest.
Yeah, so it is good to sort of know where you want and who you want.
And you got to think about where that money's going and what it's for. Some of the partners of some of the law firms I've worked in, they drive the latest Porsche, Range Rover. They holiday in Hawaii and go golfing with John Key. What are you really paying for? Is it the private school of their kids, or are you paying for advocacy?
Exactly. And I think that's the main thing, is just making sure you're getting your money's worth. And that doesn't necessarily mean going to a lawyer.
Yeah, that's true. Yeah. Okay. Yeah. I mean, and I guess maybe just to finish up, that's a really good point. And I've been saying to people that there are really 3 steps you should be taking to try to find the right advice and try to find out what you should be doing. Maybe you can let me know your thoughts about it. But the very first thing you should be doing is doing your own research, and then trying to find out if you can satisfy yourself about your situation, about your position, based on what you can find online. But when you're searching online, be careful about where you look, right? Start by searching with government websites, right? If you have the brain power and the knowledge, the language skills to read legislation, go to the legislation. If you don't, okay, at least go to the government websites. In your case, employment.govt.nz. In our case, immigration.govt.nz, where we go to the source. And if you still can't really satisfy yourself, that's fine. Go and research yourself online at places where there are professionals who are publishing free information about how to interpret those sources. So, people like yourself or myself, we're often publishing articles, holding these talks, and there's plenty of information online. The reason I say step 1, step 2 is because often people jump those 2 steps and they go to step 17, which is talk to your friends, right? Now, your friends are often the first place you go to, but they're the worst, right? Really, if you've done step 1 and step 2 and you still can't figure it out, your friends may be able to help guide you somewhat, but really what you should be doing in step 3 is talking to a professional directly. Find someone like yourself, like myself, who offers that initial consultation without charge, and who can perhaps look at the issues and determine, what's the best way forward. You might find that some people are charging for that consultation, some don't. Some of them are only charging because they just want to make money. Some of them are charging because they're too busy and they really need to be careful with their time. But at the very least, talk directly to somebody who knows what they're doing. There are probably steps 4, 5, 6, 7, 8, 9, 10 before you should talk to your friends and take advice from them.
Yeah, I absolutely agree with that. And I can't tell you how many times I've had to pick up a case after an employee has written to their employer based on information they've gotten from their friends. And I just have to look at this and think, this is why the employment relationship is not doing well. I will personally, when I give free advice, I will help people use the right language or terminologies when they're writing emails to their employer. Because that sort of communication, when you're writing an email, it can be so easily misunderstood.
That's right.
And it's so important. That's why you do your own research. Just copy and paste the employment law website if you really need to. And if that doesn't work, then you can talk to someone like me about what other issues you can talk to your employer about. But certainly the worst thing about sometimes going to your friends is they're not experts, and also they can get quite emotive. And one thing you want to try and avoid is getting really emotive and upset and angry and then writing emails on that basis.
That's right. Emotive is one thing. And the other problem that we see all the time is, everybody has one friend who has one success or failure story, which is completely out of the ordinary. And I often end up drawing a diagram for people. I say, look, here's one guy who, through chance or random success or failure, either got or declined a visa that they shouldn't have, right? It shouldn't have happened that way. It was a mistake or something went wrong. Let's say, for example, they've applied for a visa. They should not have been given a 3-year visa, but they did. And instead it should have been a 1-year visa, right? And they got a 3-year visa, and it's random and it should never have happened. And 99.99% don't get that result. But that one guy then tells 5 friends, and they all know the story. And then those 5 friends also tell their friends. And the story goes like this: I've got a friend who, in these circumstances, got this visa. And then everybody who gets told that story then feels that they've got that one friend.
Mm-hmm.
So now you've got person 3 rungs down the chain this way, and 3 rungs down the chain this way, who have been told the story, and now having a conversation at a party. And one of them says, oh, I've got a friend who got that visa. And the other one says, oh, really? I know somebody who got that visa too. And now there are 2 people, but actually only 1. And that 2 quickly goes to 4, to 8. And before you know it, the whole community has the story, and they think it's common because one guy got it. Right. And so when you look at it like that in a diagram, you realize, oh, that's right. This is a random occurrence. Don't take the advice from that person. Let's just talk to someone who actually knows what they're talking about.
Absolutely. And I had the same thing here when people say, I know someone that got a $50,000 settlement. And I'm like, well, there might be some different factors, but that's not normal.
Yeah, that's right. Okay. Well, look, I think today's been really productive and quite helpful. We can wrap it up there. Any people who are watching this, look, if you have any specific questions for myself, you know how to get in touch with us through Facebook, through our contact details. Ashleigh's website as well. We're going to put the link in the description. We'll put some links there for your website. What's the best way to get in touch with you, Ashleigh? What do you prefer?
Honestly, I am, I guess, a product of social media. I am always online. I've been getting a lot of Facebook messages through my Facebook page, Ashleigh the Advocate. But I also respond to text messages, WhatsApp, emails, and phone calls probably actually the worst way, because if I can type a lot quicker than I can speak. And so I might have to schedule a phone call though, if that's what's needed.
Yeah. Okay. All right, great. Well, thanks for today. And we'll talk again soon. Hopefully we can do another one of these soon.
Perfect. Thank you very much.
Ashleigh.